Hello. Hello.
Hello.
Yeah. Should I start? You're not saying anything? Okay. So today we are going to study state responsibility. Why states can be held responsible? Can states be held responsible? Can countries be held responsible? That's what we have to discuss today. Countries, there was a time when people were think that countries can do no wrong. Can a country do wrong? Can a country commit crime? The answer is very difficult in the earlier times. In the earlier times, it was said that the king can do no wrong. You might have heard this maxim in the law of courts. The king can do no wrong. But now, in the 21st century, can a king do wrong? The answer is yes. Can a country do wrong? The answer is yes. But suppose if the question is, can a country commit crime? The answer is no. A country cannot commit crime, but individuals of the country, they commit crime. So you have to distinguish. At the outset, you have to distinguish between two types of acts of a country. One type of act may be that a country may commit a wrong. If you remember the basic distinction between commission of a wrong and commission of a crime, then you may be very clear that a country may commit a wrong or a country may commit a crime. So, yes, somebody showing me some notes that is written. Good. Good. You are all studying. Yeah. So what I was telling you that a country can commit a wrong or a country can commit a crime. What I was saying that a country can commit wrong now. In the 21st century, no country can say that we are a sovereign. We are a sovereign. We cannot commit wrong. Sovereigns can't commit wrong. But this is not a correct statement today. The countries can commit wrong. Very good that you are helping. Who is this? Who is helping me with the page on state responsibility? Yeah. Thank you. So, yeah, these are the cases that you have to study. What is this? Topic number 4, state responsibility. Thanks for helping. Good.
Sir Rohini.
Ah, good to see you. Yeah. So this is state responsibility chapter we are studying. And what we are saying that the states, the countries can commit a wrong today. However, a country cannot commit a crime. Why a country cannot commit a crime? Because the crime is committed, a country will have to be punished. How will you put the country to jail? So we say that the theory is that we can hold the individuals of a country responsible for commission of a crime. But as a country, you can say that a country has committed a wrong. You know, there is a distinction between two words, wrong and crime. Wrong is a civil thing, civil act. Wrongful act is a civil act, whereas the crime is a crime against the whole society. So when we talk of the states, the countries under international law, we say a country is responsible for a wrongful act. You understand? Wrongful act. So whenever there is a wrongful act committed, a country may be held responsible. That is called state responsibility. Right? This is topic number 4. In 21st century and in the late 20th century, the countries can now be held responsible for commission of a wrongful act. You know, so there are some words that you must remember. There must be wrongful act, right? Or maybe that you can say that what is the first thing that you have to study in this topic? Basis. The basis of international responsibility. Yes, very good. The basis. What is the basis of international responsibility? Now, if you want to learn about the basis of international responsibility, you will have to see in your study material draft code. The whole draft code which is prepared by International Law Commission, right? So in this page, maybe that in the next page you might have, you may see that what is the page number of that draft code, you know. So in the next page, you will see that there is a draft code on next page, not on this page. Next page, next page, next page. Not this page. Next page, you'll find that there is a draft code on a state responsibility, which is prepared by International Law Commission. I may have told you about International Law Commission. What is that? International Law Commission is that kind of commission, which is like our own Law Commission of India, you know, which is given the task to make laws, to draft laws, to show it to the whole Ministry of Law, and then Ministry of Law may again finally give it to the Parliament to pass a law on it. Right? So likewise, there is International Law Commission, which is given the task to draft the laws for the whole international community. And in doing so, International Law Commission has prepared a draft code on state responsibility. Right, so this is the draft code which is given in your study material. On, I don't know what is the page number, maybe it may be 90 on your study material. I'll just show you. This is the draft code. Where is that? This one is a draft code. Draft code. Draft code stage. Just yeah, fine. Thank you. Yeah, that is the draft code on state responsibility. So this is the draft code on state responsibility, which is drafted by International Law Commission. You see in the bracket, just on the just below the title, draft code, you will see adopted by International Law Commission in 2001. No, have you seen that? Yeah. So International Law Commission. So yeah. 2001. International Law Commission adopted by International in 2001. So this is the draft code which is prepared by International Law Commission for the guidance of the whole international community. And this has become the basis of holding the state responsible for the commission. Now, if you look at Article 2 of the draft code, Law Center 2, Article 2. If you want to just start state responsibility, the law on state responsibility, we will have to start with Article 2 of ILC Draft Code on State Responsibility. And if you look at Article 2, you will see that Article 2 says what are the elements of internationally wrongful act of the state. And in that Article 2, you will find again two elements. What are those two elements? First, that the conduct in question must be constituting a breach of international obligation of the state. Okay. Article 2, subparagraph B, it says that when the conduct of a state constitutes a breach of international obligation of the state, then it is a wrongful act of a state. And second is that when the conduct of the state is attributed to the state under international. So there are two things. First, that the conduct of the state constitutes a breach of an international obligation. Now, within this, right, you must note two things. First, that there must be an international obligation of a state. Now, you can unmute yourself for 1 minute and you tell me that how there is a possibility that there will be an international obligation on the state. You can unmute yourself and say how there can be an international obligation upon the state.
Treaty, custom.
Very good.
State must be signatory of the treaty.
Very good. Yeah. So treaties, if the state has signed a treaty, then state might have taken a responsibility. The state might be obliged to do something. Obligation. Very good. You have underlined obligation. A state might have taken obligation, right? In that case, so normally, this is the very general example that treaties, under treaties, countries can take up obligation, right?
Okay.
There are also other situations. I'm not going to confuse you by taking up many other examples of, you know, how an obligation can be taken up by the state without signing a treaty by, you know, a way of a custom or by way of other kind of like jus cogens or any other kind of like erga omnes. I'm not going to confuse you with all these. So basically what you have said is correct. What you have said, that countries can take up an international obligation by signing of a treaty. Right? So this is the first thing, that a country has taken up international obligation by signing a treaty. And second thing is that the country has breached its obligation. So if there is an international obligation taken up by the state, and second, that the country in question has breached that obligation, then what may happen? Then the third thing is that country has committed internationally wrong. Okay. But again, you will find that how can a country, you know, because country is a lifeless entity. The state is a lifeless entity. So how can a country commit internationally wrongful act? Now in that case, what happens? Please mute your sounds. Yeah, thank you. So what I was telling you that the state is a lifeless entity. And how can you say that the action of a state will constitute a breach of an international obligation of the state, unless you hold a person, doing something which is a breach of international obligation. So ultimately what happens that the third thing that is coming into our consideration is that the act of the individual is attributable on the state. Yes. So somebody like you will become an IAS officer tomorrow, or you will become a leader tomorrow, political leader tomorrow, or you can become a judge tomorrow. You will represent the state, and in that case what will happen that how your act will constitute the act of the state. This is called attribution. You attribute the conduct of an individual on the state. This is how you see that the first Article 2, subparagraph A, what does it say? When the conduct is attributable to the state under international. So this attribution, there is a word attribution, you must remember. It's like law of torts that you have read. In law of torts, what you have studied? You have studied about vicarious liability. Do you remember that? Vicarious
Yes, sir.
liability, yeah. So vicarious liability is the same kind of thing. There was a time your law of torts teacher might have told you there was a time when a state could not be sued. But now even the state, the government can be sued now in the law of torts. And you might have read so many cases starting from, what was that, P and G case, which was in the British time. So what was that? Steam Navigation Company versus something like that. So in that way, this topic becomes very easy for your exam. Suppose if you have good command over the law of vicarious liability in law of torts, then you may understand this topic very easily. You see, so just try to remind yourself about the law of torts. What I was telling you, that this question of attribution, somebody might have committed a breach of the obligation which is taken up by the state, but ultimately a state can be held responsible. So this is Article 2 in the ILC Draft Code. What does it say? That a wrongful act of a state must be attributable to the state under international. And there are whole law on attribution, how you will hold a country responsible for the act of an individual. There are 7 to 8 articles in the ILC Draft Code. Those are called rules on attribution. What are those articles? Those articles are starting from Article 4 of ILC Draft Code. Article 4, 5, 6, 7, 8, 9, 10, and 11. How many are there? 8 articles. There are 8 articles which lay down the rules on attribution. Those are the rules of attribution. Sometimes in the exam, some of the rule on attribution that will be asked. You see. So out of these 8 rules of attribution, you will have to at least know, out of 8, you have to know about 1, 2, 3, 4, 5, 5 at least. So 5, 5 बोले तो unmute yourself. 5 बोले तो
मुट्ठी.
very good. So 5 rules of attribution we'll try to understand. What are those 5 rules? We will first of all start with Article 4, which is conduct of organs of a state. You know, organs of a state. How many organs of a state are there?
3.
Yeah, very good. What are those?
Legislature, executive, and judiciary.
Very good. Yeah. So Article 4, in fact, deals with the acts of these 3 wings of the state. Article 4 says that the conduct of any state organ shall be considered an act of the state under international law, whether the organ exercises legislative, executive, judicial, or any other functions. Whatever position it holds in the organization of the state, and whatever its character as an central government or of a territorial unit of the state. So suppose if tomorrow you become a judge in Isagari or in your state or in High Court or Supreme Court of India, and you oversee the obligation contained by a state, or you willingly violate an international obligation, ultimately you know who will be held responsible. State. The state can be held responsible. You see. So this is, attribution. This is vicarious liability, that you do one thing and the state may become responsible. You become an IAS officer tomorrow, you will become a part of executive, and knowingly if you violate an international obligation, what will happen? The state may be held responsible. So people say that no, international law is of no use. People say that international law is having no practical utility. People say that international law has no kind of monetary value. But you see that how this is touching everybody's lives. You do anything, you become the organ, you become the legislator tomorrow, you become an MP tomorrow, and what you do, that you knowingly you violate an international obligation taken up by our country. What may be the possibility? The possibility may be that the state, the country can be held responsible, because the conduct of the organ of the state is attributable onto the state. Is it clear?
Yes, sir.
Good. So Article 4 deals with the first rule of attribution, which is the wrongful act committed by the organ, any organ of the state. Now I'll be moving on to Article 5 of ILC Draft Code, which is another rule of attribution, which says that conduct of persons or entities exercising elements of governmental authority. What is that? There are some persons who exercise elements of governmental authority. So it's not itself a government or the part of the government, but it exercises elements of governmental authority. Right? And if you look at the content of this article, it says that if a law has empowered somebody to exercise element of the governmental authority, then the act committed by that very person can be attributable onto the state. That is Article 5. So Article 5 says that sometimes what may happen, that Parliament might pass a law giving some entities or some person the power to exercise governmental authority. Now, in that case, if that person also commits a breach of international obligation, that act of that individual may be attributable onto the state. You see, so this is Article 5, and sometimes you might be thinking that suppose if you become the member of some paramilitary forces, uh, like CRPF or any other paramilitary forces, and then you think that okay, now we are not the organ of the state, but we are just paramilitary. But then they are also exercising, and they have been empowered by the Parliament to exercise elements of governmental authority, and therefore, if they will violate uh, any kind of obligations taken up internationally by the state, that may also be attributable on the state. Okay, Article 5. So till now we have covered 2 rules of attribution. This morning I'll try to cover 5 rules of attribution. I'm not going to take up all these 8 rules of attribution, because all these 8 rules of attribution you may not remember, and I am very happy when my students will at least remember the basic things, even for the examination. So 5 rules of attribution I am going to take up. In your examination also, only 5 rules of attribution might be asked. Maybe direct question may be asked on 1 or 2 rules of attribution, but maybe that you may discuss all these 5 rules of attribution, because in the examination, whatever you remember, that you do. We are now moving on to Article 6. What is that article? Article 6 is about the conduct of organs placed at the disposal of a state by another state. What is that? When the conduct of any organ of a state is placed at the disposal of a state by another state, that shall be considered an act of the former state under international law, if the organ is acting in the exercise of elements of the governmental authority of the state at whose disposal it is. What does it mean? It means that sometimes, suppose if you remember that many times India accuses Pakistan that Pakistan is using its ISI to do many things, many activities, illegal activities in India. So suppose if the question is that if ISI is controlled or it is at the disposal of Pakistan, then what may happen? That Pakistan may be held responsible. And therefore the question will be always, like, you become a lawyer tomorrow, what you have to do is not simply say like what people say that okay, ISI is responsible, but you must try also to say that ISI, the conduct of ISI can be attributable on Pakistan. And how will you do it? You will have to do it when you can establish the link, and that link should not be a very loose link. The link should be a strong link, right? So Article 6 says that the conduct of organs placed at the disposal of a state. You must establish that how ISI is at the disposal of Pakistan as a state, right? So this is how you see Article 6 says that if a country, and I will also take you to the case in some time, maybe today I may not be able to do it, but I will discuss some cases, then you will understand perhaps in a better way. But Article 6, what Article 6 says, that whenever any organ of a state is placed at the disposal of another state, then the state may be held responsible. Right? Till now, if you have any questions, please ask. You can unmute yourself for 1 minute.
Sir, in this article, organs are of state or कोई भी हो सकता है?
नहीं, कोई नहीं हो सकता. Organs of state हो सकता है.
Okay.
Yes. अगर तुम कहो कि कोई प्राइवेट बंदा वो हो सकता है, आंसर इज नो. उसके लिए हम दूसरे आर्टिकल पे जाएंगे. उसमें आर्टिकल 6 कवर नहीं होगा.
Okay, sir.
Good. Any other doubt? Okay. So now I am moving on to Article 7. Article 7 says that sometimes what may be the possibility? The possibility may be that the conduct organ of a state exercises the power in excess. Right. So the organ of the state was not supposed to exercise the power in excess, but the organ of the state exercised it in excess. You know, excessive authority, excess of authority. Or sometimes what happens that the higher authority has given you a particular instruction to do. And what you have done, you have contravened those instructions. Now, in these situations are covered under Article 7, which says that in a case where the organ of a state or person or entity empowered to exercise elements of governmental authority shall be the act of a state if the organ, the person, the entity has exceeded its authority or contravened the instructions. So, when you become tomorrow, suppose if you become any responsible authority of a state, you must follow the instructions given by your superior. If you do not, yeah, but validly, it must be valid instruction, of course. It should not be, illegal instruction, right? If there is an illegal instruction given to you, you should simply say that, no, it's illegal. Yeah, you don't have to fight even then. You should just say, okay, sorry, but this is something which is illegal. Yeah, but what Article 7 says that if you have contravened the instructions, which was valid instruction, and what you are doing something illegal by contravening the instructions. The authority which was given by the parliament might be something, but what you are doing, you are going to exceed your authority. And it's not simply just exceeding your authority, but it's also when you exceed your authority and when it goes up to the level that it constitutes a breach of international obligation. Only then so Article 7 is going to deal with these kind of situations when an official or when an entity is tasked with responsibility, but it has either exceeded responsibility or it has contravened the instructions, and ultimately it is breaching the international. That is Article 7. If you have any doubt on Article 7, please ask. Yeah, you can unmute yourself now for 1 minute.
Sir, if you specify this thing something, so that would be of easily understandable for each of us.
Yeah, can you please repeat yours?
This I got it. Although Article 7, this is something related to vicarious liability of this case, absolute vicarious liability. But if you give some example to demonstrate it, that would be helpful for us comprehensively understanding
That's
purpose.
what I was saying, that suppose if you become an IAS officer tomorrow, and you had to do something in a particular situation, like for example, take the current example of this lockdown, and suppose if the authority which is given to you is not to harass the people, right? And if you start harassing the people, but again, it may not be a breach of international obligation. It will become a breach of international obligation when your exercise of excess authority is also a breach of a treaty obligation, or it is constituting a breach of some international laws. Only then the state can be held responsible. Okay?
Okay, sir. What I wanted a practical demonstration actually, not a practical demonstration. Something it could be something like in case of for an example of lockdown. If somebody would it be a proper example I'm asking from you? I don't know. So if in case of a lockdown, if something like is instructed that you have to maintain the law and order situation, and if you kill somebody or if you shoot somebody in maintaining that law and order situation, so would such kind of thing would make the state responsible or not?
Yeah. So that's what I was saying, that there are 2-3 steps. No, first step is that you are exceeding the authority which is given to you. Second is that it is
Yes,
going
sir.
to violate a domestic law. Okay. The third is that it is going also to violate
Okay, agreed, sir.
international law. Yeah. So it may be a violation of domestic law, but it may not be the violation of international law. That's what is a state responsibility.
But sir, specifically in this case, which I have put in front of you, before you, is basically in this case there is no specification of that. You have to maintain law and order.
Yeah.
So
So
in that sense,
yeah, but in this case, is there any treaty on it? Has India taken up any obligation internationally?
I am assuming yes.
No. Yeah, because this is not any kind of treaty is signed in view of this whole pandemic. India is doing it on its own. So there may be a violation of domestic law, but there may not be violation of international law.
Okay,
Is it right?
right, sir.
Okay, good. So this is how Article 7 must be understood. And now I am going on to start Article 8. Article 8 is very important. I have asked questions on Article 8 and Article 6. Article 4 and 5 are, very easy. Article 6, one time I had asked question. On Article 8, I have asked questions 2 times. What is that? It is conduct directed by the state, or a conduct which is controlled by a state. Okay. If you look at the content of Article 8, it says that the conduct of a person or group of persons shall be considered an act of a state under international law if the person or group of persons in fact acting on the instructions of or under the direction or control of that state in carrying out the conduct. Right? So suppose if government sends a group of people who may not be the organ of a state. You see, Article 8 is that. They are not the organ of a state, but they are controlled by the state. You know, this may be also a possibility. Nowadays, what is happening that in some cases, some countries, what some countries do, some countries take up the help of the private people to do something in other state or maybe in their own state, so that they will not be held responsible, because they will ultimately say, no, we are not having any relationship with it. But Article 8 Draft Code is very clear. It says that if the group of persons are acting on the instruction of the state, or they are doing whatever they are doing under the direction of the state, or the control of the state is there, the state may be held responsible. There can be attribution on the state. This act of the group, this act of the individual of that group may be attributable on the state. This is very important. And in this case, I will take you to Nicaragua example. We will discuss Nicaragua case. We will discuss Corfu Channel case. We will discuss Barcelona traction case. There are so many cases that we will discuss, but on Article 8, we will discuss Nicaragua case. You study Nicaragua case today, and when we will meet tomorrow, we will discuss Nicaragua case. We will also discuss Corfu Channel case. We will discuss Barcelona traction case. And what are the other cases that you have to study? You have to study Iran's case. Yes.
Sir, I have a question. Can I ask with respect to this Article 8?
Rajneesh.
Hello. Yes, sir.
Yeah, Rajneesh, tell me.
I have a question. Sorry, I am interrupting you because I thought you are finishing actually. So
Yeah.
I need to interrupt you.
Yeah.
I am asking, what is the difference between Article 5 and 8, sir? Both the articles look same. Pretty, maybe slight difference or
Very good. You see that this is the importance of the class, that you're sometimes, if you are not going to understand, then I will make you sharper. Very good. Article 5 and Article 8 looks like same. But what is the distinction? In Article 5, if you may notice now, Article 5 had said that the government or the state had empowered somebody to exercise governmental authority.
Right, sir.
Okay? But in Article 8,
Yes,
there is no such empowerment by law. Okay? What Article 8
so
says?
it could be to anybody. There is no empowerment. It could be anybody.
Anybody, but then the state must control them.
Yes, sir. Okay.
Okay.
Right.
Very good. So we will discuss the cases. I told you what are the cases that I will discuss tomorrow. I'll discuss tomorrow Corfu Channel case, Barcelona traction case, Iran's case. Very important example of Iran's case. And this is given in your study material. Please read it. Nicaragua case is also given in your study material. And then Lagrand case on rule of attribution, Lagrand case. So tomorrow we will discuss all these cases. Let us see how many cases we will finish, because Perhaps I will not be able to finish all the cases in one go, but definitely we will try to discuss many of these cases. What I was telling you, that Article 8 is important. 5, 4, 5, 6, 7, 8. Yeah. So 5 rules of attribution that we have studied today. 5 rules make you stronger. 5 bole to muthi. And today what we have learned, that we have seen that state can be held responsible for commission of any wrongful act. And how can a state be held responsible? How can you actually hold a state responsible? On that we have discussed rules of attribution, right? So 5 rules of attribution we have seen. Also, after we will discuss these cases, we will also discuss in ILC Draft Code, we will discuss part 2 of ILC Draft Code, and part 3 and yeah, in part 2 chapter 1, in part 2 chapter 1 and 2 we'll also discuss. Okay, so yeah, very good. This is part 1. Yeah, but you just flap some pages, you'll find part 2, which starts with Article 28. Yeah, Article 28. So 28, and we'll also see 30, 31, 32, and we will move on to Article 34, 35, 36, 37, 38. All these things will be studied, right? So thank you very much. If you have any questions, please ask.
सर आपने आर्टिकल 6 में IS का एग्जांपल क्यों दिया था?
आर्टिकल 6 में?
यस सर.
ISI का दिया था, IS का नहीं दिया था.
ओके ओके सर.
ISI और ISIS अलग है.
ओके सर. ओके.
Any other question, please?
सर एक बार इस एग्जांपल कोड समझा दीजिए प्लीज.
कौन सा?
यही आर्टिकल 6 का जो ISI का एग्जांपल दिया था आपने.
मैंने ये कहा था कि ISI को हम कहते हैं ना कि ये चीज ISI ने करवाया.
हाँ जी.
वो ISI ने करवाया, सब कुछ ISI ने करवाया, लेकिन इससे हम पाकिस्तान को रिस्पॉन्सिबल नहीं बना सकते. हम पाकिस्तान को रिस्पॉन्सिबल तभी बना सकते हैं जब हम ISI के कंडक्ट को पाकिस्तान के कंडक्ट के साथ जोड़ पाएंगे. Because we must have to establish, वो establish करना पड़ेगा कोर्ट में, that whether they are at the disposal of Pakistan. प्रूव करना पड़ेगा. Article 6 says that an organ which is placed at the disposal of a country. तो अगर ISI is placed at the disposal of Pakistan, then Pakistan can be held responsible for the act of ISI. वो मैं कह रहा था.
Okay, sir.
Anything else?
One question more I want to ask.
Yeah,
this is with regard to when there are provisions both in the international law and as well as in domestic law with regard to a particular matter for XYZ. So which law would prevail in the International Court of Justice?
That I have already discussed it yesterday also, and day before, maybe before.
You said that domestic law will prevail, I think.
Yeah, if there is a direct conflict. If there is no direct conflict.
Okay.
अगर हम दोनों को हम साथ लेके चल सकते हैं, तो एकला चलो रे भी ठीक है. That was विशाखा वर्सेस स्टेट ऑफ राजस्थान कि हमारे देश में कोई लॉ नहीं था, तो इंटरनेशनल लॉ के से लेके हमने एकला चलोड़े कर दिया, सुप्रीम कोर्ट ने बनाया था ना, वो पूरा गाइडलाइंस बनाया था।
ये हाँ
यस हाँ, और जब हमारे देश में जो कानून